Indian judicial review is inspired by the American Constitution. The doctrine of judicial review was propounded for the first time in the famous case, the Marbury vs. Madison by John Marshall, the then Chief Justice of American Supreme Court. Uh, Judicial review is a doctrine is a basic part of the Constitution, basic structure of the Constitution. What is the meaning? Judicial review is the power of the judiciary to examine the unconstitutionality of legislative enactments and executive orders of both central and state governments. In other words, it is a type of court proceeding in which a judge reviews the lawfulness of a decision or action made by public body. For example, you can see लेजिस्लेटिव या एग्जीक्यूटिव कोई लॉ बनाती हैं उसकी कॉन्स्टिट्यूशनली चेक करनी होती है ना कि वो वेदर इट्स अ कॉन्स्टिट्यूशनल और नॉट इलीगल और नॉट वैलिड और नॉट ठीक है तो उस बेस पे वो उस लॉ को चेक किया जा सकता है तो उसको नल एंड वॉइड किया जा सकता है इनवैलिड इलीगल कुछ भी किया जा सकता है सो बैक देयर इज सम काइंड ऑफ बैकग्राउंड so the Government of India Act 1935 empowered the Federal Court to scrutinize the violation of constitutional directions regarding the distribution of powers and reduction of federalism in India. So it is not this power of judicial review is not like specially provided in the constitution, but the constitution being federal, the federal court was entrusted impliedly with the function of interpreting the constitution and determining the constitutionality of legislative acts. The Supreme Court of India is nothing but the Federal Court of India after the commencement of Constitution. पहले इसको Federal Court बोला जाता था तो constitutional provision देख लेंगे. Judicial review is nowhere found in the Constitution. However, the provision of several articles explicitly confer the power of like directly judicial review नहीं लिखा गया है Constitution में, but कुछ of the articles हैं वो indirectly say करते हैं कि explicitly बोलते हैं कि judicial review is there. Coming to this Article 13 we have studied तो मतलब जो भी article या laws that are inconsistent with the derogation of the fundamental rights are to be shall to be null and void. और 32 is like कि कोई भी fundamental right violate होता है that should you can have the power to go to the Supreme Court. So देखो basic क्या है किसी लॉ को null and void कर देना फंडामेंटल राइट्स को भी वो सक्सेस करें या फिर वायलेट करें या डेरोगेट कर दें तो बेसिकली वो भी आ सकता है ठीक है रिट्स इशू किया जा सकती है 131 प्रोवाइड द ओरिजिनल रिस्ट्रिक्शन ऑफ द सुप्रीम कोर्ट इन सेंटर स्टेट एंड स्टेट डिस्प्यूट्स ठीक है these kind of indirect articles we have studied these also will not go in this so the doctrine of judicial review under the Indian Constitution in India in India, the Constitution itself confers the power of judicial review on the judiciary, both Supreme and High Court. Further, the Supreme Court has declared the power of judicial review as the basic feature of the Constitution or an element of basic structure of Constitution. तो Supreme Court ने बोला है कि this is judicial review जो है basic structure के अंदर आता है. Hence, the power of judicial review cannot be curtailed or excluded even by constitutional amendment से भी इनकी जो powers है जुडिशियल रिव्यू को चेंज नहीं किया जा सकता ठीक है However, judicial review cannot be conducted in respect of laws the ninth schedule. Let's see type of judicial reviews. The review of legislative actions and constitutional amendments. The review implies the power to ensure that laws passed by legislative are in compliance with the provision of Constitution. अब इन अगर देखो अगर कोई भी लॉ पास करती है लेजिस्लेचर वो इन compliance with the Constitution that is good. This is a tool of enforcing constitutional discipline over administrative agencies by exercising their power. तो administrative action मतलब रिव्यू करना उनके एक्शन को मतलब बेसिकली देखना कि एक कॉन्स्टिट्यूशनल डिसिप्लिन मतलब और रिव्यू ऑफ एडमिनिस्ट्रेटिव एक्शन अगर बेसिक जो लॉ बनेगा वो एडमिनिस्ट्रेशन से होकर ही आएगा तो अगर वो अच्छे से काम करेंगे उनका काम रिव्यू होगा तो बेसिकली हम उस लॉ को ही रिव्यू कर रहे हैं बेसिकली रिव्यू ऑफ जुडिशियल डिसीजन The review is used to correct or make any changes in the previous decision by the judiciary itself. अपने decision को correct करना. इंडिया यूएसए के बीच में, so we'll not go into that. So we'll just American has due process of law and we have a procedure established by law. ठीक है, two difference हम देख चुके हैं due process of law what. This gives wide scope to the Supreme Court to grant protection of rights of the citizens. It can declare laws violation of these rights void on not only substantive grounds but on the procedural ground को भी unvalid कर सकते हैं. Will not go into this. So this is procedure established by law. Due process of this Indian side. देखो, अगर हमने प्रोसीजर जो एस्टेब्लिश किया है, अगर हमने वो फॉलो किया है कोई लॉ बनाने के लिए, तो वो अच्छा है. ठीक है, it not only checks there is a law to deprive the life and personal liberty of person but also sees if it law is fair. बेसिकली आर्बिट्रेरीनेस चेक भी होती है, यहाँ हमारे इसमें नहीं होती. It does not assess whether Parliament's laws are fair, just and not arbitrary. It checks laws made by Parliament are just fair and arbitrarily fair होनी चाहिए laws. यहाँ fairness check नहीं होती. A law duly enacted is valid even if it's contrary to principle of justice and equity. देखो, जस्टिस के इक्वलेंट भी कोई लॉ बना सकते हैं उससे ऑपोजिट, तो वो वैलिड है. लेकिन यहाँ पे दैट इज अनफेयर. Challenges of constitutional validity of law. The constitutional validity of a legislative enactment or the executive order can thus be challenged in the Supreme Court or in the High Court. 3 grounds. फंडामेंटल राइट्स को इन्फ्रिंज करते हो, अगर मेरी अथॉरिटी के अंदर नहीं था फिर भी मैंने बना दिया कानून, तो हो जाएगा अनवैलिड वैलिडिटी. रिप्यूजेंट टू द कॉन्स्टिट्यूशन प्रोविजंस, मतलब प्रोविजंस के भी खिलाफ है वो. Repugnant. So I don't know the meaning of that. Let's see it. Okay, unfavorable. हाँ, that is good ना, मतलब जो प्रोविजन है उनसे वो अनफेवरेबल है. ठीक है. Instances of the judicial review of these kind of cases we have. Evolution we have. We will not go into evolution. Application of basic structure doctrine. The doctrine of basic structure of the Constitution was reaffirmed and applied by the Supreme Court of India in the Gandhi case. In this case, the Supreme Court invalidated the provision and kept the election dispute involving which kept the election disputes involving the Prime Minister and Speaker of Lok Sabha outside the jurisdiction of court रखे, outside रख लिए elections को. The court said the provision was beyond the amending powers of Parliament and it is affected the basic structure of Constitution, that is not valid. वो नहीं होना चाहिए. और these are some of the cases we have not got the cases. लेजिस्लेशन के लिए list of right as a part of Article 21. So we have seen the Article 21, so we will not go into this. I think yes. So India basically follows the procedure established by law. Okay. So these are the case studies. Critical analysis में देखिए importance. It is essential for upholding and maintaining the supremacy of Constitution. That is very much known. मतलब Constitution की supremacy के लिए judicial review होना जरूरी है. पॉसिबल मिसयूज ऑफ पावर, तो मिसयूज ना कर सके लेजिस्लेटिव एग्जीक्यूटिव, तो भी होना ज़रूरी है. फंडामेंटल राइट पे जाता है ये. फेडरल एक बैलेंस बनाता है सेंट्रल स्टेट के बीच में. इंडिपेंडेंस ऑफ जुडिशरी बनाए रखता है. प्रिवेंट्स द टायरनी ऑफ द एग्जीक्यूटिव. लिमिटेशंस की है, ये कॉमन फंक्शंस को ये मतलब रेस्ट्रिक्ट करता है थोड़ा सा. ठीक है, लिमिट कर देता है. Violates the limit of power said to be exercised by Constitution which it overrides by any existing law. Was valid. In India, the separation of functions rather than its power is followed. Functions rather than of power is followed. तो बेसिकली सेपरेशन नहीं था कि जुडिशरी अपना देखेगी और ये अपना देखेगी एग्जीक्यूटिव लेजिस्लेचर। बट अगर आप इस लॉ को जुडिशियल रिव्यू के अंदर डालते हैं तो वो सेपरेशन ऑफ पावर में थोड़ा सा इन्फ्रिंज करती है। वही सेपरेशन ऑफ पावर इज नॉट एडहर्ड टू स्ट्रिक्टली, ठीक है। चेक्स एंड बैलेंसेस तो हैं। Our system of check and balance has been put in place in such a manner that the judiciary has the power to strike down any unconstitutional law passed by legislature. The usual opinions of the judges once taken for any case become the standard, ठीक है, वो standard बन जाते हैं फिर। Conclusion: with the power of judicial review, the court acts as a custodian of fundamental right, of course. With the growing function of modern state, judicial interventions in the process of making administrative decisions and executing them has also increased. When the judiciary surpasses the line of power set for it, and namely judicial activism, it could be rightly said that the judiciary has begun to invalidate the concept of separation of power. तो बेसिकली होना ज़रूरी तो है, लेकिन अगर जुडिशरी अपनी हदों को पार करता है, दैट इज़ नॉट सेपरेशन ऑफ पावर्स अगेन, ठीक है। Making laws is the function and duty of the legislature, of course. To fill the gap in laws and implementing them in a proper manner is the responsibility of executive. So there is only that is the only work remaining for the judicial is interpretations. मतलब देखो, लेजिस्लेचर ने क्या किया, मेक कर दी लॉ, बना दी है, ठीक है, बन गया लॉ। अब इम्प्लीमेंट इन प्रॉपर मैनर किसकी रिस्पॉन्सिबिलिटी है, वो गवर्नमेंट की रिस्पॉन्सिबिलिटी है। तो एक ही काम बचा इस लॉ को अच्छे से इंटरप्रेट करना, ठीक है, दैट इज द जुडिशरी के लिए। The founding fathers are wisely therefore incorporated in the constitution itself the provision of judicial review so as to maintain the balance of federalism. It's basically not the busy. The functions of judicial review is thus a part of the constitutional interpretation itself. It therefore adjusts the constitution to meet new conditions and needs of time. Dr. B. R. Ambedkar, who chaired the drafting committee of Constitutional Assembly, has described the provision art of the constitution. Of course, यार देखो, डिक्टेटरशिप तो होनी नहीं चाहिए ताकि मतलब देखो हर कोई चाहता है जनता का भला। मे बी आई एम सीइंग फ्रॉम पॉजिटिव पॉइंट ऑफ व्यू कि हर कोई यानी कि लेजिस्लेटिव और पार्लियामेंट चाहती है, लेकिन चेक एंड बैलेंसेस होना चाहिए ना। अगर आप कानून ला रहे हो, पार्लियामेंट बना रही है, इनेक्ट कर रही है गवर्नमेंट, तो चेक्स एंड बैलेंसेस के लिए जुडिशरी का होना ज़रूरी है ना। ऑफ कोर्स यहाँ पे लॉ द कॉन्स्टिट्यूशन को ध्यान में रखा गया हो, उसके अकॉर्डिंगली बनेगा, अपनी पावर्स को देखा गया हो कि हम बना सकते हैं नहीं बना सकते, कौन सी मिनिस्ट्री बना सकते हैं कौन सी नहीं बना सकते। अकॉर्डिंग टू दैट ही वो मतलब एक गुड इंटरप्रिटेशन मिलनी चाहिए और इसको जुडिशरी देखना चाहिए कि इट इज़ गुड और नॉट। Coming to the judicial activism in India. Coming to the judicial activism, so it is a type of judicial philosophy. It holds that the judiciary can and should go beyond its duty, consider broader societal interests of its decisions. ठीक है, what does it mean? Like interference of judiciary in the legislative and executive domain. ठीक है, in brief, judicial system implies or judicial activism implies that instead of judicial restraint, the Supreme Court and other lower courts become activist and compel the authority to act. बेसिकली लेजिस्लेटिव और एग्जीक्यूटिव के काम में इंटरफेयर करना किसी अ गुड रीजन की वजह से। गवर्नमेंट को डायरेक्ट भी कर सकते हैं विदाउट अबाउट द पॉलिसीज एक्सेट्रा। It is referred also as judicial dynamism, which means a proactive role played by judiciary to safeguard the rights, मतलब basically right citizen के हित में well-being of the people of India to interfere with the legislative and executive. So we'll not go in the evaluation. Important features of judicial activism देखो, हेल्थ की एरिया में भी देखो 1995 में सुप्रीम कोर्ट asserted that health is the basic right of people. Accordingly, the doctors were brought under consumer laws के अंदर, ठीक है। Education integral part, environment should be good, ठीक है। Child labor should be prohibited, ये पहले corruption should be not be there, Traffic regulation of traffic, political frontier. So reasons and causes of judicial activism. So failure to have responsible judicial activism जब गवर्नमेंट फेल हो जाए किसी केस में कोई कानून तो बना दे बट दैट इज नॉट अ वैलिड रीजन. Fundamental rights to be restored are to the citizens. If the government or any of its agency look down on the fundamental right of citizens, the citizens can approach the court of cause. And judicial enthusiasm to participate in the reform and change of cause. किस चीज़ में change करना हो, ठीक है? The constitutional scheme for judicial intervention, Article 13, empowers the judicial to review the validity of any law on the touchstone of fundamental right and उसको void कर देना, null and void कर देना अगर वो infringe कर रहा हो laws को, ठीक है? Fundamental right of course. कुछ सिचुएशन जो जुडिशियल एक्टिविज्म को लेड करती हैं दैट आर द फेलियर ऑफ लेजिस्लेटर टू डिस्चार्ज their responsibilities. Legislators की failures to discharge their responsibility when the government is very weak of course. कॉन्स्टिट्यूशन वैलिडिटी पे ना चल रही हो गवर्नमेंट तब मिसयूज हो रहा हो तब गवर्नमेंट की तरफ से और अनदर थिंग्स मैनिफेस्टेशन ऑफ जुडिशियल एक्टिविज्म public interest litigations. Now, PL is the most profound manifestation of judicial activism. PL is a powerful instrument devised by the judiciary to reach out directly to the public. The tool takes cognizance through the litigant as well as the suo motu concept of the courts. A postal letter or even a postcard addressed to the court is admissible for the purpose of initiating prerogative and exclusive rights. तो बेसिक क्या है बेसिक ये यहाँ PL is nothing, it's a like it's a powerful instrument to go to the court and giving your like appeal for some law infringement. Judicial review. The Constitution of India provides for judicial review under Article 32, which is Supreme Court article, and 32-26 High Court. This gives the power to apex court to examine the constitutionality of the law. When such a law is found to be inconsistent with the provision of Constitution, then law be declared unconstitutional कर दिया जाता है. Some of the interpretation हमें चाहिए इसमें International Convention and Statute. Okay, we'll not go in this. Landmark cases and there are some of the famous cases. Okay, the judicial review, activism and overreach. In the words of Prime Minister at the Conference of High Court 2007 April, courts have played a salutary and corrective role in innumerable instances. They are highly respected by our people for that. At the same time, the dividing line between judicial activism and judicial overreach is a thin one. So let's see the difference judicial review और activism के बीच में. So it is just the constitutional validity check करना. Active review is just that. So it's a proactive role of judiciary when the legislative and executive organs are inactive. तो एक्टिविज्म मीन्स कि किसी जगह पे एक्टिव करना जाके जब भी लेजिस्लेटिव एंड एग्जीक्यूटिव ऑर्गन्स जो इनएक्टिव हो जाए तब एक प्रोएक्टिव रोल प्ले करना बाय जुडिशरी. आर्टिकल 13 तो ये कॉन्स्टिट्यूशन से तो नहीं है इंडियन कॉन्स्टिट्यूशन में तो नहीं है बट इट इज टेकन फ्रॉम द यूएस जुडिशरी ऑफ कोर्स. Judicial activism versus overreach. Uh, it upholds the rule of law and deterrent spirit. It impedes the functioning of healthy democracy. Adheres to the doctrine of checks and balances, separation of powers. Activators of judicial activism. It's the people, Now comprehend that judiciary has constitutional powers for it of intervention. This power can be invoked to alleviate their suffering occurring from repression, governmental lawlessness, and administrative deviance. According to the eminent justice, social right activist, this is not much important. Now, देखो जैसे कुछ एक्टिवेशंस हैं कि vulnerable section women and children, so right of women groups and child action groups, litigated issues, equality, violence, illiteracy, juvenile custody, etc. So judicial activism versus judicial restraint. The growing number of cases involving judicial overreach sparked a debate about restraint as a preventive measure. So judicial activism is the proactive role played by the judiciary, whereas judicial restraint means self-control exercised by judiciary to limit itself over the original intent of constitution maker. देखो, एक्टिविज्म मैंने बता दिया, गवर्नमेंट जब इनएक्टिव है तो प्रोएक्टिव रोल प्ले करना पड़ेगा उसको, हम जुडिशरी को, बट जुडिशियल रिस्ट्रेन मीन कि अपने आप को कंट्रोल करना, कुछ एक्सरसाइज करने से, कुछ लॉ बनाने से, कुछ किसी पे इन्फ्रिंज करने से जुडिशरी खुद को कंट्रोल करना जुडिशरी है ना, मतलब मैं जुडिशरी हूँ तो मैं खुद कंट्रोल कर रहा हूँ, सेल्फ कंट्रोल एक्सेस करें जुडिशरी को। क्यों? क्योंकि मुझे कॉन्स्टिट्यूशन मेकर का ओरिजिनल इंटेंट चेंज नहीं करना, यानी कि बेसिक स्ट्रक्चर चेंज नहीं करना मुझे उसका। तो जुडिशियल एक्टिविज्म में देख लिया इनेबलिंग है एंड दिस इज रिस्ट्रिक्टिव, आपको रोक रहे हैं खुद को। क्रिएशन ऑफ सोशल पॉलिसीज हेल्प टू प्रिजर्व बैलेंस एंड पावर, ठीक है। ओके, लेट्स मूव इन। These are some observation, we will not go into this. This is the critical analysis. Coming to the PILs. So we have also seen this is what is PIL. The introduction of the PIL is India facilitated by relaxation of traditional loopholes locus standi. According to this rule, only a person whose rights are infringed is moved to court. Under the PIL, any public spirited citizen, कोई भी हो, मतलब लोकल स्टैंडर्ड का मतलब वही जाएगा जिसके इन्फ्रिंज हो गए, बट यहाँ पे आजकल क्या है, पीआईएल के अंदर कोई भी जा सकता है। What is PIL? In PIL, any member of the public having sufficient interest can approach the court for the enforcement of the laws. मेरे भाई enforce नहीं होना, evolution will not go into this. Need of PIL. So was vindication of the rule of law, facilitate effective access of justice, the meaningful realization of cause features, poor masses के बीच में law, PIL does not advisory character, masses के right को protect करना, cooperative effort, grievance redressal of course, proactive and creative efforts. Scope of PIL, let's do this. Inclusion, boundary labor matters, neglected children. These are like include किए गए इन चीज़ों को. These are some of the things we'll see in detail again. Exclusion में आप लैंडलॉर्ड टेनेंट मैटर्स को नहीं आते, PIL के अंडर सर्विस मैटर्स नहीं आते, ये सब मैटर्स नहीं आते. प्रिंसिपल्स ऑफ PIL. बेसिकली ये भी इंटरेस्ट का नहीं है इतना. Against whom PIL can be filed? State government, central government, municipal authorities, and not any private party. Government and parliament, government and legislation, all local authorities within the territory of India. Procedure तो देख सकते हो. These are the thing guidelines for admitting PIL in India. Landmark judgments हैं. Significance of PIL in India. PILs make justice accessible to the poor people. Of course, it is important tool to make human rights to reach those who have been denied. It democratized access to justice for all. Of course, it helps in judicially monitoring state institutions. Important tool of judicial review. Limitations. Uh, of late, PILs have become a tool of publicity, of course. छोटा मोटा चीज़ों में PIL कर देते हैं. That's why. Concern the overuse of abuse of people make it ineffective, of course. Because बार बार अगर आप ineffective सा unabusive यूज़ करेंगे तो वो चीज़ नहीं रह जाती उतनी powerful. And many times PIL is a public, but it becomes a personal thing, so that is not good. Politically sponsored cases are filed. That is not should be done. In such petition, they are not disposed of a petitioner favor. The date of such judgment is dubbed as a black day of the judiciary. In such petitions are not disposed of in the petitioner's favor. देखो कोई भी petition फाइल तब करता है जब उसको कोई ज़रूरत हो. गलत आदमी थोड़ी ना करेगा. अगर वो हार ही जाते हैं ऐसे तो फिर ब्लैक डे ऑफ जुडिशरी बोलते हैं उसको. ठीक है. पिटीशन के फेवर में ही नहीं आया डिस्प्यूट डिसॉल्व. The court should not allow its process to be abused by politicians and not to delay this process. The PIL activists should be responsible and accountable, of course. The court must be careful to see the petitioner must be acting bona fide and not be personal gain के लिए ना हो. So this is for now. I will again. This is why because it's not as important as, but you should know about that. So we'll see this in detail as well. But we'll just move in further because we have been moving late. We have to do the high court and tribunals. Then we just move further. Thank you.